Welcome to the Legacy Cast by Kelley Legacy Law.
Hey, everybody. Welcome to an all-new episode of the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. I'm your host, Mike Leon. You know, Mike's practice, they focus on helping families enhance their lives today and secure their future tomorrow. And we're looking in today's episode at how trust can be designed around your family's unique situation, whether you're a married couple, a blended family, or you're just planning on your own. How can a trust help you? So, Mike, it's good to see you as always. Let's talk about how trust, sometimes families, I think, they think of a trust, it's like a one-size-fits-all type of document. But I know you know that it's probably a little bit more flexible than that.
Yeah, thanks for having me again, Mike. I always enjoy educating people on these issues because there's so many people that just don't know anything about trust, or they think that they are for mega wealthy people that we've heard of trust fund babies and things like that. They don't realize that trust planning with a living trust is actually a foundational level planning. We talk about a last will and testament where some people don't do anything at all. They don't have any documents. Well, the living will is another option. The living trust is another option besides a last will and testament. So yeah, one size fits all planning. I mean, that's not even something that I consider doing at my firm. To me, every family is so different, whether it's your asset structure, your family structure, traditional, blended, whatever it is, that we have to find out everything we can about you from an asset standpoint, family structure standpoint, motivations, goals, the whole person, the whole family, before we can ever sit down and really advise you. And it's about outcomes. A living trust can be used by single individuals to accomplish certain things. Married couples, some folks have been married for 40, 50 years. They have a different structure that they want to set up that's going to work better for them than a blended family, a married couple that has children from previous marriages. So, yeah, definitely no such thing as one size fits all.
So let's dive into what you just said there about the differences between setting up, let's say, just an individual trust or a joint trust for married couples. Can you kind of explain the differences?
Yeah. So when we talk about individual trust, we've got a married couple and we look at, all the factors that go into it and decide is a separate trust for each individual best, or should we do a joint trust, which is just one document that covers both people? So, if we have a situation where we have, each spouse has certain assets that they really want to keep classified as their separate assets. So if there is a divorce down the road, potentially, okay, we know that this asset was intended to be hers. This was intended to be his. Okay. So sometimes they may want to provide that whatever they have that they're keeping as a separate asset will go to their children ultimately and not go to their spouse's children. Okay. So putting assets in an individual or separate trust for each one of them makes sense in that scenario. There may be assets that are both. They may have things that they consider to be separate assets that they want in separate trusts, but then sometimes we'll do a joint trust for them as well, where we'll have joint assets owned by that trust, or maybe we'll have joint assets where each of their separate trusts owns a part of it. So we can do it a lot of different ways. But that's, having the separate trust for that reason. Plus, sometimes we have a spouse that's a professional, like a doctor or an attorney, or someone who is going to have some sort of professional liability involved with what they do. So we may want to have separate trust for the spouses to keep some assets, positioned in a way that if the professional spouse gets sued, those assets will be protected. So that is a reason why a married couple would have separate trust. But like I said, sometimes married couples come in to see me and it's a blended family, but they've been married a long time, so much so that they consider the kids from the first marriage to be their kids, even though they're just stepchildren. And they say, look, all of our assets we consider to be both of ours. We consider all these children to be ours. So we're good just doing one joint document. It doesn't matter who dies first. The assets are going to go, the same way. So it just depends on the family.
So let's talk a little bit about one spouse potentially passing away. How does the trust work for the survivor compared to the part that's set aside for the deceased party?
Well, in that case, we're going to be talking about a joint trust because that's where we get those two shares. If we have separate trust, then we don't have a survivor or a decedent share. We just have the assets in that trust and they're going to be used by those people. But in a joint trust, when the first person dies, we do have the assets split into two shares: a survivor's share, a deceased person's share. The surviving person's share, they get to continue to use the way they always have. It stays in a continuing revocable trust that they can use for whatever they want. Okay. The deceased person's share, which is half of the joint property plus any separate property that this person had, is going to be held in irrevocable trust. Okay. So that our surviving spouse, they've got their survivor's share, they can still be trustee over the deceased person's share and still benefit from the assets held there, but they cannot ever change that irrevocable trust. They can't take the property and do with it whatever they want to with it. They can't amend it or revoke it. So we know, as the person who died first, when our surviving spouse dies, whatever property is left in that share is going to end up going down to our kids. So it's a way that the person that died can protect assets to make sure their children are going to get something while their surviving spouse can still use it.
So, Mike, let me ask you, what kind of decisions, you touched a little bit on it here, but couples, when they come in to meet with you, what kind of decisions do they need to make ahead of time so that way they can be sure that the surviving spouse is truly, truly protected?
As far as decisions they need to make ahead of time, the surviving spouse ultimately is going to be fine. There's some trust that we set up where the surviving spouse gets everything. Okay. And then there are some where the surviving spouse only gets their share. Now, I will say this: in the scenario where we have a deceased spouse's assets that are segregated off, okay, we protect our surviving spouse, number one, by making them trustee over that still, so they can still access it. So they're not cut off from the deceased person's assets. Number two, we can put provisions in that don't seem to protect our surviving spouse, but really do. So we can require that if our surviving spouse wants to get remarried, that they have to get a prenuptial agreement in place that will protect the assets from a potential, new spouse. All right. So the deceased person's assets are going to be off limits, except to our surviving spouse. And then there are things we can do, like we could take our marital home and we could put it over with the deceased spouse's share in that irrevocable trust, so that if our surviving spouse goes out and gets in a car accident, they get sued, there's a judgment against them, the judgment creditor is not going to be able to seize the marital residence because it's now in the name of this irrevocable trust that's part of the deceased person's share, not in the surviving spouse's share. So I think that's, as far as the surviving spouse goes, that's the few of the things we can do to help.
A moment ago, you were just talking about blended families. Can you elaborate a little bit more? Like, what extra considerations come into play when they're structuring a trust?
Yeah, like I mentioned earlier, there are trust structures we can draft where everything goes to the surviving spouse. If you take that route and you have children from a previous marriage, you're the first person to pass away, our surviving spouse can change the entire estate plan. They can revoke the trust, restate it, amend it, to cut our children out. Okay. So that's a consideration. And, the other structure we've been talking about here is where the deceased spouse's part doesn't automatically go to the surviving spouse. It goes off on its own and is held in another's. So, that's a blended family consideration, is how do we structure that if we're going to use this one trust? And look, I have people come in here, they have blended families, they've got a lot of assets, they have children from previous marriages, and they say, we want to do model number one where everything goes to the surviving spouse. And I warn them about the potential for disinheriting their children. And they say, we trust our spouse completely to do the right thing. And I say, okay, I need you to sign this acknowledgement saying that I told you that this could happen, because if and when it does, I don't want your kids coming to me as the estate planning attorney saying, why did you let dad draft this or sign this? Because we got disinherited when stepmom decided to do something different. So that's a policy I have, but ultimately the client gets to choose what they want to do. So, but we always lay out all of those options and make sure that blended families especially know these are the potential benefits of doing it this way, and here's the potential hazards that you could be running into.
Mike, you mentioned about, some of the options that you lay out for them. What risks do families face though if they just pick, like, let's say, a standard trust and they don't tailor it at all to their situation? Do they face any risk?
Well, you can get into a lot of things depending on what kind of assets they have, and how the trust is drafted. Do they if they make their trust beneficiary of a retirement account, okay, they could be accidentally causing a massive tax problem for their kids, or their spouse that they didn't recognize that they were going to be making. Okay, so as far as we've talked about some of the drafting issues previously about things that they need to look out for. So you know I don't even know what a standard trust is, to be honest with you, because maybe if you're getting one on trustandwill.com where you're typing in, filling in blanks, I guess that would be a standard trust. I'm just so accustomed to making sure that we go through the whole picture of the family. Now there are standard provisions. Okay, do I want to make specific distributions to a certain person, a certain amount of money to this exact person? How do I want the rest of my property to go? Where do I want my personal property to go? Okay, so there are standard things that we're going to cover in every trust. Okay, but we're never going to have standard answers for every single individual. Mm-hmm. So that's what I would say. There's no such thing as a standard trust for me.
So Mike, someone's listening to this, maybe they're a little overwhelmed, they haven't created a trust yet. What's the first step towards designing a trust that truly fits their family?
Well, I think the first step is doing something like this, but then also maybe going out. I do a lot of seminars. I try to do one once a month here in my local area, wherever this person is, where they are. Hopefully there's attorneys doing that, going out and just giving free education, so that you can begin to learn what the difference is between having a last will and testament plan and a living trust plan. What's going to be the right thing for you. So, there's a lot of assets out there on the internet, Google, ChatGPT, Grok, all that kind of stuff. It can be good and bad. That sometimes you get bad information from those things, but, just a general, educational level, would be good to have, and then seek out legal counsel to say, okay, this is my situation. I know a little bit about it. I've heard this, that, or the other. And then you need to find an attorney that is a teacher at heart, because that's what we do. We teach. And there's no way for you to know what outcome is best for you unless someone has been teaching you and educating you enough so that you can make a good decision. So that's what I would say.
Mike, thank you for the time and insights on this. As always, we truly appreciate it.
Thank you so much for having me. I always enjoy it.
And thank you for everybody out there listening to another installment of the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. If you want to learn more, visit kelleylegacylaw.com. Don't forget to like, subscribe, leave us a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.